Hello, everyone. Welcome to the panel here. This is Bears Ears and Beyond. This is Bears Ears and Beyond. Can Trump dismantle national monuments? Our panelists will be discussing the Antiquities Act and, more specifically, recent actions by the Trump administration to reduce the size of two national monuments in Utah. First, we'll have Professor Mark Skloas. He is a professor at the University of Colorado Law School and served as the Director of National Resources at the Law Center at Colorado. Before that, he taught at the University of Toledo and at the University of Wyoming. And he is a former Fulbright Scholar and the co-author of various articles on the Antiquities Act and other environmental laws. In 2000, Professor Skloas took a leave from law to serve as special assistant to solicitor at the U.S. Department of the Interior. And there he worked directly with Bruce Babbitt, the secretary, on a wide range of policy issues. So I'd like to welcome Professor Skloas.
Thank you, Michael. As many of you know, my last name is Squillace, not Skloas, but we've just met, Michael. So thank you, Michael, anyway, for the introduction. And look forward to talking with you about something that I care deeply about, our national monuments, and in particular, a couple of the monuments that have recently been at least threatened with change. I'm not willing to concede that they have been legally changed by President Trump, but we'll get to that here in a minute. So I have a couple of tasks today. Let me just start by showing you or talking briefly about this montage of different pictures of some of our national monuments. And maybe the most surprising on the picture is the Statue of Liberty, which most people don't recognize as a national monument. But the Antiquities Act, which I'll talk about here in a minute, is a law that allows the president to designate all kinds of different types of important features on our landscape, including historic landmarks and historic kinds of structures. And the Statue of Liberty is one. President Clinton fairly recently designated a building called Soldiers' Home in Washington, D.C., which was the summer cottage that President Lincoln used. You may recall that President Obama recently designated the Stonewall Inn in New York, which is now a national monument that sort of celebrates the LGBT community and its ascendance. So I want to just talk a little bit about these. I'll show you some of these pictures again as we go through the slides. We can talk about any of the particular monuments that you might be interested in. What I'd like to do, though, are really two things this morning. First, I'd like to tell you a little bit about the Antiquities Act, because we start talking about national monuments, and I think we lose a little bit of the context. And then after that, I'd like to talk specifically about this important legal question as to whether or not the president has the authority to dismantle national monuments. All right, so let's just talk a little background here on the Antiquities Act. First, let's just think about how we got this law. And what happened, this is right around 1900. There's a lot of concern about looting of artifacts on public lands, particularly some of the ancient Anasazi sites in the southwestern part of the United States. There were actually some major museums throughout the world that were excavating sites, taking them back to their museums, and several congressmen and supporters of the public lands were worried that this public treasure was going to be lost, certainly lost to the area where it existed. And so 3 bills were being circulated in the Public Lands Committee of the House, chaired by Congressman John Lacey from Iowa. And these 3 bills were a wide range of different restrictions and provisions for protecting these ancient areas. Some of the bills were very narrow, focusing on just protecting small areas around these ancient sites. Others were much broader, included language that would have allowed the president to essentially protect national parks. And you can see one of the bills that came out, one of the original bills was sent to Interior, and the Interior proposed language that was in the broader category. Now, if you think about it, this is 1906 when the Antiquities Act is passed, and we don't yet have a national park system, at least in the sense that we think of it today. The National national parks. Yellowstone was created, the first national park in the world, in 1872. Yosemite follows not so long thereafter. A couple of others, Sequoia National Park and a couple of others, are created before 1906, but not the system that we have today. And so many at Interior wanted to give the president broad authority to designate national parks. This sort of goes through several years of debate in the House, and what finally emerges is this language you see on the slide now, language that essentially allows the president to protect objects of historic or scientific interest. And note, this just sort of flips the language from one of the original bills that had been proposed in 1900. Note, they talked about objects of scientific or historic interest. What comes out in the final legislation is essentially the same. Here's the Antiquities Act in sort of an edited form, but the key language is here. What does the Antiquities Act empower the president to do? Well, he gets to declare by public proclamation historic landmarks, historic and prehistoric structures, and other objects of historic and scientific interest as national monuments, and he gets to reserve those lands. I want to talk about that word reserve here in a minute, and he is limited to the smallest area compatible with the protection of the objects that are indicated in the proclamation. Okay, so some limits and some broad language. So Teddy Roosevelt's president when the Antiquities Act is passed. He has only less than 3 years left in office, and in the course of those 3 years, he designates 17 national monuments, including some really significant ones. Some of the proponents of the Antiquities Act thought it was only going to be used for things like Chaco Canyon, which is a famous sort of area where there are lots of important archaeological sites. Chaco Canyon indeed is designated as a national monument. But the first one, it turns out, is in Wyoming, Devil's Tower. You probably recognize, if you've ever been out there, an area that is essentially designated because of its geologic interest. And it's obviously an impressive structure in the middle of Wyoming. Okay, so Roosevelt does a bunch of them, but probably his most important, and not just because it's the Grand Canyon, is the Grand Canyon National Monument, right? More than 800,000 acres of land designated by President Roosevelt as the Grand Canyon National Monument. Why is it so important? Well, it led to the case that really, I think, set the stage for some of the debate today over the president's authority over national monuments. Here's the case, Cameron versus United States, decided unanimously by the U.S. Supreme Court in 1920. And who was Cameron? Well, he was quite a character. There's been a fair amount written about Ralph Henry Cameron. He was basically a mining prospector. But Cameron's real strategy was to take advantage of tourists who wanted to get down to the bottom of the Grand Canyon. So he had all these mining claims. He had actually a mining operation. I think it was called the Last Chance Mine. It was a copper mining operation near the Grand Canyon. But he ended up locating a bunch of claims strategically along the Bright Angel Trail. And at the time, the Bright Angel Trail is the basic way in which people would get down to the bottom of the canyon. It still is today. But some of Cameron's predecessors actually were involved in constructing the trail. Cameron had a license to essentially charge people a toll to come down the trail because he had been, or his predecessors had been involved in constructing the trail. But he eventually lost that ability to charge people, so his response was to locate these mining claims in strategic points where you would have to cross his claims to get to the bottom of the Grand Canyon. And he would charge you $1 for the privilege of crossing his claims. This really upset the Santa Fe Railroad Company, which had a partnership with the hotel at the rim of the canyon. The guests at the hotel wanted to take the trail down. They didn't like paying Cameron $1 to get through his claims, and so there was this fight that took place between Cameron and the hotel over whether or not he'd be allowed to continue to do that. And Cameron's claims, I think, were generally thought to be pretty weak in terms of their validity. And that was the problem. Essentially, the hotel, the railroad company, they basically complained to the Department of the Interior. The debate goes all the way up to the Secretary of the Interior, who at the time was James Garfield, and Garfield decides that Cameron's claims are not valid, and he has to basically vacate the claims. Cameron was a sort of a wily politician. He later became a U.S. Senator from Arizona, but he basically just refused to vacate the claims. And eventually the Justice Department has to bring an action against him to get him off of the land so that people can go down to the canyon without having to pay Cameron a fee. They do that. Cameron appeals the case, contesting his claims all the way to the U.S. Supreme Court. And one of Cameron's essential claims is that the president did not have the authority to designate this large landscape, the Grand Canyon, as a national monument. And the court says, of course it does. The Grand Canyon is the greatest eroded canyon in the United States, if not the world. It looks like an object of scientific interest to us. And again, unanimous decision from the court, and again, sets the stage, I think, for a lot of the large monuments that we have today. Okay, so the Grand Canyon is not the only controversy, obviously, and it's not the only controversy before the current controversies that we have over our monuments. There were some really interesting ones during the middle part of the history of this law. There was a national monument designated again by Teddy Roosevelt, the Mount Olympus National Monument, which is now the core of Olympic National Park, over 600,000 acres, designated by Teddy Roosevelt. Woodrow Wilson comes along and cuts it in half, cuts out more than 300,000 acres out of the original monument. The circumstances surrounding the reduction are not entirely clear. Some have suggested it was to promote a war effort to provide more timber for construction of boats. There clearly was some animus on the part of the mining and timber industry that didn't like the fact that a lot of the land that was included in the monument was off limits to them for mineral development and for logging. But whatever the reasons, Wilson reduces the size of the monument. It's never challenged, although it's extremely controversial within this nascent environmental community that's building. Okay, so the other interesting controversy, I think, that's worth talking about is over the Jackson Hole National Monument. So Jackson Hole was designated by Franklin Roosevelt in 1943. When it was designated, there was already a small Grand Teton National Park. It only included the High Peaks area, a few of the upper mountain lakes in what is now the Grand Teton National Park. John D. Rockefeller comes to Franklin Roosevelt and says, I'd like to protect land around the Grand Tetons. I will donate to you over 30,000 acres of land if you will designate a large monument adjacent to the peaks. Roosevelt does so. Big controversy in Wyoming. The Wyoming delegation is furious with Roosevelt for designating this new monument, and Roosevelt does it anyway, partly because the condition on getting the land for Roosevelt is that he designate a monument. So Cliff Hansen, who later became a U.S. Senator at the time, is this county commissioner from Teton County, drives this cattle drive through the new monument illegally to try to protest the monument. The Wyoming delegation is furious with what's happened. They hold hearings, they try to get the monument repealed, they fail, and ultimately, it takes quite a number of years, but ultimately they accept that the new monument is going to stay in place. They work out a compromise, and the only amendment to the Antiquities Act was passed as a result of this controversy. It does not allow any new monuments in the state of Wyoming. Wyoming is unique in having that distinction of not being allowed to have new monuments. What's really interesting, I think, about this controversy is that Cliff Hansen and Alan Simpson and a number of the other major leaders in the state of Wyoming now all admit that their opposition to this monument was a mistake. It was the best thing that ever happened to Teton County. If you've ever been up to the Grand Teton National Park, you would probably agree. It is quite an attraction. It's quite an interesting place to visit. I wanted to, I think I'm missing some, where's my picture of this of us? And I'll come back to this particular issue later when I talk about some of the legal issues. Just briefly on the current controversies over Bears Ears and Grand Staircase, I think what's most important to recognize about these decisions is that they are unprecedented in scale. What President Trump has done, or at least tried to do, was to take more than 1 million acres out of Bears Ears National Monument. As designated by President Obama, 1.35 million acres, 85% taken out, only 201,000 acres now left in the Trump proclamation. Grand Staircase, almost 1 million acres taken out of the 1.87 million acres in the original monument. A little more than half is left in. It's about 46% smaller. The closest that comes to this is the Mount Olympus reduction that was done by Woodrow Wilson. Most of that land was put back in when Congress created the Olympic National Park. So this is really unprecedented in terms of restricting access. Just a couple of additional slides before I get to the second issue that I want to talk about today. This is Peekaboo Gulch. It's a famous little slot canyon down in southern Utah. It was in the original monument. It's out of the new monument as designated by President Trump. So one of the interesting geologic features, I guess you'd say, in the new monument. It's really a cool place. When we get a chance to go down to Peekaboo, I encourage you to do it. And here's a figure of Bears Ears. This is one of the many famous cliff dwellings in the Bears Ears Monument. I don't know exactly where this picture was taken, so I don't know whether this is still in the monument that has been designated by President Trump. What we can say, though, is this. Some of you may have seen this story in the Washington Post from just a couple of weeks ago, a major new paleontological find in the Bears Ears National Monument, or actually in what used to be the Bears Ears National Monument, in the original boundaries of the monument, this major find of phytosaurs and other kinds of specimens there. It's just really interesting. If you think about Bears Ears, some of the experts who have looked at the resources in this area have estimated that there may be as many as 100,000 different ancient sites that are worthy of protection in the monument. We haven't discovered many of these. Okay, so here's the key question I want to talk about today. What is the president's authority to modify national monuments? Well, the issue starts with the property clause of the Constitution. The property clause tells us that it's the Congress that has the authority to protect public lands. The Supreme Court has described it as plenary authority, essentially unlimited kinds of authority. But the president can delegate that authority to the executive branch. And so the Antiquities Act is a delegation of authority to the president to reserve, by public proclamation, national monuments. The key problem here, though, is that delegations are construed narrowly because Congress is giving part of its power to the executive, and that delegation is supposed to be construed narrowly. What did the Congress give? The power to reserve. Congress did not explicitly give any power to modify or revoke monuments that were declared. And so a textualist, someone in the mold of Justice Scalia, would presumably think that the statute only gives one-way authority. Any support for that legal position? Well, I think there's pretty good support. If you look at two contemporaneous statutes on either side of the Antiquities Act, the Pickett Act of 1910 and the Forest Service Organic Act of 1897, Congress explicitly delegated power to both withdraw lands, which is like reserving lands, and to modify and or revoke the withdrawals that were made. So you can see the language in the Pickett Act. You can withdraw lands for certain purposes until you revoke them. And in the Forest Service Organic Act of 1897, where you could set aside forest reserves, the executive could reduce the area or change the boundary of such reserve, or may vacate altogether any order creating the reserve. So very different sort of delegations of power than under the Antiquities Act. There is an Attorney General's opinion from 1937, Homer Cummings, who was the Attorney General during the Franklin Roosevelt administration, basically says that when President Roosevelt comes to him and says, I would like to get rid of the Castle Pinckney National Monument, a small, relatively insignificant national monument, can I do that? The Attorney General says no. In what I would call dictum, or the equivalent of dictum, the Attorney General goes on to acknowledge that, in fact, presidents have shrunk monuments in the past, and seems to suggest that maybe that's okay, but doesn't really analyze that issue. I would argue that the issues are really quite similar legally, at least in terms of legal interpretation, but we've never had a question of modification challenged in court. We've had maybe, I mean, the numbers I see vary on this, but we've probably had at least a dozen, maybe more modifications. Most of them have not been terribly significant. The biggest was the Mount Olympus National Monument reduction. There were a few others that were, a fairly large number, but as a percentage of the total monument, I think not quite as significant. but again, never challenged in court. What about this argument about the smallest area compatible? Remember the original language of the law said that when the president designates a national monument, they're only allowed to designate the smallest area compatible with the protection of the objects. And this comes out in the Trump proclamations, where there is language in the new proclamation suggesting that the president did not designate the smallest area compatible. But think how this is going to play out in court. How exactly does the Trump administration show that the administration, the Obama administration, did not designate the smallest area compatible? When you have evidence like the new paleontological find in Bears Ears, how is it possible that you shouldn't include those kinds of lands within the monument? Some really interesting questions are likely to come out in the litigation. We'll see. I said I was going to come back to the Grand Teton National Monument, and I want to because there was an interesting case decided in that situation, a case called Wyoming and Frankie. It's a case from the Wyoming District Court, and you can see what the court confronted in this case. Basically what happened was the state of Wyoming comes in and says, this isn't monument worthy, this is just sagebrush. It's just grazing land. There's nothing here worth protecting. The government counters with testimony from the renowned biologist Olaus Murray, from the director of the Park Service, and from other scientific experts who testify about the important resources at the National Monument. And the court says, I can't second guess this stuff. As long as there's sufficient evidence in the record to support the president's decision, then the monument gets to stand. You can see the specific language that the court offers. Okay, just a couple of other points I want to make. There's been a lot of debate about the Federal Land Policy and Management Act of 1976. Interesting law that essentially rewrites all the rules on on withdrawals. So there are lots of different types of withdrawals. The Antiquities Act is just one. The Public Land Law Review Commission that basically was the study group that led to the passage of FLTMA. They come up with recommendations that Congress essentially get rid of all of the other withdrawal authorities, and they put them all under FLTMA now, a new provision in FLTMA that gives withdrawal authority. But Congress decides not to do that, and one of the few statutes they decide to preserve is the Antiquities Act. Now there's some curious language in FLTMA. There's this provision 204J that says that the Secretary can't modify or change a national monument. The Secretary never had any authority, still doesn't, under the Antiquities Act, so it's a little hard to know what Congress is getting at. I've written a little bit about what I think may have happened here, but an important point here from the legislative history of FLTMA, and this comes out of the final House report on the law that became FLTMA, is language that specifically says that Congress is reserving to itself the power to modify or revoke national monuments. To be fair, some judges won't look at legislative history, but this is pretty powerful evidence that I think Congress intended what is, I think, clear from the original statute, that the president only has the power to reserve, not to revoke or modify. There's a good policy argument here, too. If you think about what's going on, what Congress is doing is asking the government, asking the president to set aside some lands that need protection, that we think ought to be preserved, or the president thinks ought to be reserved, and we'll decide later whether or not that preservation, that protection should stay in place. It's very interesting, I think, that Congress has actually abolished a few national monuments. No significant monument has ever been abolished by the president. I think the biggest one is a little over 2,000 acres. None of the big monuments have really been changed. What actually the president has done in most cases is expand. Enlarge the monuments, has made many of them into national parks. So I think there's a compelling reason why it goes only one way. Just one other point I want to make about this whole debate. We're in litigation right now over both Bears Ears and the Grand State of Escalante National Monument. It's not clear how it's going to go, but it's worth just reminding ourselves that this is sort of special litigation because the plaintiffs are suing the President of the United States, and the President, as many of you know, is not an agency for purposes of the Administrative Procedure Act, so there really are no clear rules that apply to litigating a case against the president in these monument cases. We've had a few other cases like it. It's kind of interesting to think about what's going to happen. No clear standard of review here. No clear administrative record policy. That is, will the case be decided on the existing record, such as it is? Will the court allow testimony and other evidence to be brought in? We don't really know at this stage. It's something interesting we should all watch. And just sort of in closing, think about all the different areas that have been protected. There have been 16 presidents who have designated 157 national monuments over the history of the Antiquities Act, a little more than 100 years now. And some of the really interesting areas that were first protected by the Antiquities Act, and I think that would never have been protected, or at least would not be the same today, but for the Antiquities Act, include places like the Grand Canyon, which I think would have been developed for hydropower and mining before we got the protections that Roosevelt put in place. Mungatui, kind of a famous monument, now we call it Zion National Park, designated early on by President Taft. Sur de Mont, the Acadian National Park, began as a national monument. And you can see Bryce Canyon, Glacier Bay in Alaska, Arches. I'll just leave you with this final thought. The state of Utah is quite upset about the new national monuments, and they've made their views quite clear. The state of Utah also has a major campaign to advertise their national parks in southern Utah. They have 5 national parks in southern Utah. Their campaign is called the Mighty 5. It's a multi-million-dollar campaign that encourages you to go down there. 4 of the Mighty 5 began as national monuments. So it's worth thinking about the importance of this area. That's all I've got. Thank you very much.
Thank you, Professor Squillace. Apologies about your name. Very interesting introduction to the Antiquities Act. It's important to note that more than half of the current national parks were first national monuments. And of the 157 designations, more than half of those have been upgraded to higher conservation designations by Congress. Similarly, this also can take a very long time. Pinnacles National Monument was one of the first ever designated, and only after 100 years was it created into a national park in 2013. So this process potentially takes a long time. And it also restricts the uses in these areas, uses that people are accustomed to and would like to pursue. So I'd like to I've lost your bio here, but I'd like to bring up Jonathan Wood. He's an attorney with the Pacific Legal Foundation, which is a organization that promotes property rights and capitalism. So, without further ado, Jonathan Wood.
All right, now we're going to see if I can work the computer and the pointer. All right. All right, so the one takeaway I want to leave you all with is that this is a political controversy, not a legal one. That there's no good legal reason why the end result here should be anything other than what it's been in all of the prior controversies that Professor Squillace previously considered or mentioned. The end result will likely be that Congress will look at whether some or all of these lands should go back into a monument, created into a national park, into a wilderness area, and whether the president's powers should be reconsidered. That's what we had happen in Grand Teton with Wyoming, and there's already legislation pending to do something like that with Bears Ears and Grand Staircase. To try to avoid that ultimately a political solution and create a legal restriction on the president's ability to change existing national monuments would require a court to reject so many long-held and commonly recognized legal principles that I think it's extremely unlikely even a court that would like to do it, would like that ultimate outcome as a political or practical matter, would be very hesitant to do that. So I want to start by telling you, be careful what you wish for. Now, we often say that elections have consequences, and one of them is that any existing unilateral executive action can be reconsidered by a new president. So almost invariably, whenever a new president is elected, one of the first things they do is change all of the regulations and executive orders and other policy decisions that their predecessors or the predecessors' agencies had implemented. Now, it would be politically convenient at any time if you liked the pre-existing regulation to say, well, does the statute expressly authorize you to reconsider this? Maybe there's a legal challenge to stop you. And so far, no court has ever gone down that road. We basically accept that it is inherent in the nature of unilateral executive action that those sorts of actions can be reconsidered and are subject to ongoing presidential politics. The only way to get permanent policy outcomes is to go to Congress and get a statute enacted. That's the kind of thing a president can't change. And so right now, these arguments might seem attractive to someone who preferred Obama to President Trump and doesn't like what President Trump is doing. But in the future, President Trump's going to be replaced. Do you really want to see a court adopt legal arguments that might make it harder or perhaps impossible to change whatever President Trump does on immigration, the environment, commerce? All of these exercises of power delegated to Congress. There's really no good way to distinguish those sorts of regulations, executive orders from national monument designations. And unless you can make that distinction, the only way to stop President Trump from shrinking these monuments as a legal matter would be to throw out the rule that allows the executive orders and the regulations to be changed. I think in the long run, nobody wants that. We want our presidential elections to continue to have consequences. Oh, and one thing I forgot to mention, I do have written materials, CLE materials. If anyone's interested, I have a few hard copies. If you prefer to save a tree, I have my email and my Twitter handle on the bottom of every slide, and I will tweet it out. And feel free to reach me by email if you'd like a copy that way. So where should we start? What is the background assumption here? And I would submit that it is the same as every other regulation, executive order, and unilateral executive action. Discretionary executive actions are inherently subject to reconsideration by future presidents. That's what we mean when we say elections have consequences. Courts deal with this issue all the time in the administrative context. Whenever a regulation is changed or revoked, the people who liked it are going to go to court and try to say, well, we don't like the change. And every case I've been able to find that considers the question of whether a statute must expressly authorize a regulation to be modified or revoked in order to give the president or an agency that power, every single one has come out the same way and said that doesn't have to be explicit. That is assumed. That's inherent in the nature of this authority. There is not a single case pointing the other direction. And I think that's telling. This is really the closest analogy to what we have here. We have Congress giving discretionary power to the executive, and the question is that subject to the changing political tides, or is that a one-way ratchet? And in every case we've been able to find, the answer comes out the same way. That this is a political question, take it up with either the president or go to Congress and try to change the statute. I think this is reflective of a broader constitutional norm. Generally, if you look across the nature of our government, you find that generally the power to act is stated expressly, but it's assumed that you can do the reverse by the same process. This is what we have with legislation. Congress is authorized to pass laws in the Constitution. There's no reference to repealing laws. Courts have the power to make decisions and issue rulings. There's no discussion about repealing past opinions. The president can agree to treaties and submit them to Congress for ratification. There's no reference to the president's power to revoke treaties, but of course they have it. And there's actually been constitutional litigation over this, dealing with the appointment of officers. There, of course, under the Constitution, the president has to nominate and get the Senate to confirm officers, but he has the unilateral authority to fire an officer, even though there's nothing expressed in the Constitution that provides that. This just is the nature of executive power. So if you're concerned about the separation of powers, I think this is the bigger concern, that this is a good thing. You want presidential elections to have consequences. If you allow one man to have the power to make a policy decision that's binding forever, that's the more radical shift to the separation of powers. So this is the way I would present the challenge. And to give my disclosure, I represent several interveners in the Bears Ears litigation. I understand Professor Squillace may also have been, perhaps not participating representing parties, but has been collaborating on those as well. This is the way I would present to the court the challenge of accepting the plaintiff's argument. And it really is a huge hurdle. First, they would have to convince a court that Congress set aside the ordinary rule that applies to all other unilateral executive actions for monument designations under the Antiquities Act. 2, that it did so silently. There's nothing in the statute to support that interpretation. And that would be unprecedented. That's the part that there is not a single case to cite for that legal proposition. 3rd, that Congress took this unprecedented action without saying anything about it at the time. You'd think if Congress was going to make this one statute that's different from all the others, in the legislative history, you'd have that smoking gun. You don't. And 4th, no one noticed Congress had done this for decades, even as presidents exercised the power to modify existing national monuments. I think taking all 4 of those together, which you'd have to convince a court of all 4 of them in order to win, is such a high burden that I think it's extremely unlikely any court, even one, as I said, that would like the ultimate outcome, would be willing to go out on a limb on all 4 of those. So let's get to the actual arguments. I'm going to start and go Constitution, statute, legislative or historical practice, and then finish up with the purpose. I think it's the easiest way for me to organize, and it somewhat tracks the way Professor Squillace began it. So let's start with the Constitution. As Professor Squillace notes, the Constitution gives Congress the power under the Property Clause to decide how federal lands are regulated. And Professor Squillace and the litigants in the case have argued, well, this should set up the presumption that unless Congress has expressly said the president can do anything, it's withheld all of that power. I see 2 problems with this argument. The first one is that it doesn't distinguish anything. All of those cases dealing with regulations and executive orders are exactly the same. They are exercises of power delegated from Congress to the executive branch. When EPA issues a regulation dealing with air regulation, it's acting pursuant to a delegation under the Commerce Clause or something else. When the president issues an executive order on immigration, he's acting based on power delegated from Congress to him under our immigration laws. And so if you accept that, so essentially to take that argument, you have to reverse all of those other cases and reverse the ordinary rule that has been applied for centuries. The second problem, and I think the bigger one, the one that I haven't seen addressed much, is that it actually goes too far if you want to defend these national monuments. There's no good reason to say that the president's power in the Antiquities Act must be interpreted narrowly, but that's only true of modifying or revoking national monuments. If this is a constitutional matter, the same thing should apply to the exercises of the designation power. So the language that you saw earlier of it's limited to artifacts, structures, objects of scientific and historic interest would have to be interpreted as narrowly as possible to protect Congress's property power from being taken by the executive. Same with the smallest area compatible. That would have to be given teeth, and we would have to closely scrutinize whether presidents went too far, because anything beyond the smallest area compatible would be a potential constitutional problem. The other concern there is that there's no reason why that should be limited to the Property Clause of the Antiquities Act. Why wouldn't the same thing apply to the Commerce Clause and every other part of Article 1 that gives Congress power and not the president? You essentially have to reverse the idea of Chevron, which says that if Congress delegates discretionary power to the president, he gets to decide how to exercise it, and reverse it completely, and say that every delegation can be construed as narrowly as possible. Well, so much for the modern administrative state. I mean, there's something attractive to that if you're concerned about the separation of powers. But I think the people making that argument today in support of national monuments don't realize that the end result is quite a few existing national monuments would be illegal under that theory, and others would have to be substantially reduced as being too large. And that's a problem I haven't seen them try to address either in the briefing or in quite a bit of scholarship that's been generated on this issue. The next point, I think it's important when you consider, is this unprecedented or is this a repeating political conflict that's been happening for over a century? The situation we have today is not your grandfather's Antiquities Act. The size and number of areas designated within national monuments has radically changed in recent decades. It took about a century for presidents to lock up about 70 million acres within national monuments. In the last 16 years alone, 700 million acres were locked up. And most of that was due to novel interpretations of the president's power to designate and to expand his power in the Antiquities Act to designate new things. So all of a sudden, land, the president's power is limited to federal lands under the Antiquities Act. In 2006, that was interpreted to mean the ocean. A previous iteration of what was going to be Antiquities Act, but was ultimately rejected by Congress, included things like landscapes and scenic beauty. That didn't make it into the final bill, but ultimately objects of historic and scientific interest has been interpreted the same way to include landscape-level national monuments, and many of the recent national monuments, including Bears Ears and Grand Staircase, are ultimately landscape monuments. The president isn't saying, well, there's an object, and here's the area around it, saying, well, this is the area, and there are lots of things within that landscape. So something has changed, so it's not surprising that we have this political conflict raising its head once again. In each of the prior examples where there was a big jump, you ultimately had a political controversy and some sort of change, including things like converting monuments into national parks while reducing the president's power. So this is really just a repeat of a long-running controversy. So now let's move on to the statute. Like all of those statutes granting agencies discretionary authority to issue regulations, the Antiquities Act gives the president absolute discretion about designating national monuments. The president is never required to designate a national monument, no matter how clear the case for one is. Even if 99% of the country, or actually if everyone in the country except for the president thought a monument was a good idea, he could still tell you to pound sand and refuse to do it. And nothing in the text forbids modifying or revoking national monuments. This is like every other statute saying, the agency can issue any regulations it deems in the public interest. It is that sort of broad, and it's actually pretty explicit. It says, in the president's exclusive discretion. There are no standards to require monuments or to constrain the ability to revoke them. Now, Professor Squatchy has identified several roughly contemporaneous statutes which he says suggest that even though Congress didn't explicitly deny this power, it's reasonable to imply that. I think that interpretation is based on a misreading of those statutes. Instead, I think they reinforce the pre-existing norm that in discretionary executive action is subject to reconsideration. And I think the text of those statutes confirms it. So let's start with the Pickett Act. No provision in the Pickett Act says that the president can revoke or modify withdrawal done under the Pickett Act. There is no explicit grant of authority. At best, it's implicit. What the statute says is that these temporary withdrawals shall remain in effect, quote, until revoked by the president, says he, the president, or an act of Congress. Now, of course, this is just referring to an implied power. It's not actually granting it. But I think what's more interesting is it pairs the president's power to do that with Congress's ability to legislate. If you try to take this language and create an argument by implication, there's no reason to distinguish the president's power from Congress's. So if the absence of this phrase means that the president can't modify monuments under the Antiquities Act, why isn't Congress similarly barred from passing new legislation dealing with monuments? And the answer is that would be absurd. But in terms of the linguistic argument, if you're trying to turn that text into a restriction on all of the statutes, that's a problem you have to grapple with. The second statute, the Forest Service Organic Act, I think is actually even more helpful. There is language that provides an express grant of authority to modify or revoke previous withdrawals. But it's clear from the legislative history and actually the text of the statute itself that Congress didn't pass that because it thought the president wouldn't have the power otherwise. It thought he would, but it wanted to eliminate any possible question about that. As best we can tell, this provision grew out of a debate in the legislative history in either this statute or one immediately considered before it, where one of the congressmen said, by granting the power to withdraw land, it's a one-way ratchet. The president can't revoke it. Other congressmen said, absolutely not. Of course he can. And ultimately, they passed the statute that begins with, to remove any doubt which may exist pertaining to the authority of the president thereunto, and then expressly grants the power to modify or revoke. This is explicitly a belt and suspenders provision that's just reinforcing the power Congress thought the president would have had anyway. There are a few others statutes that Professor Squillace hasn't mentioned, but that are cited in the litigation. They suffer many of the same sorts of things, so they'll be like the Pickett Act and don't actually expressly grant authority, but refer to it for some reason. So, for instance, some statutes affirmatively require the president to revoke a withdrawal in certain circumstances, and that makes sense. If you're going to require the president to do that, you have to expressly say so and have to provide those circumstances. But that doesn't create the implication that silence means the president can't do it. So moving on from the statute, I think tradition and the historical practice under the Antiquities Act, I think, seals the issue. It is really hard to convince a court that that the way a statute has been implemented for a century has always been illegal and no one noticed. Generally, if a court were given that question, it would say, well, if Congress thought that was true, it would have dealt with this a long time ago. Unless it's enacted new legislation to fix the situation, we're going to assume Congress is okay with what's been going on. And 6 presidents have reduced national monuments, including several of which were very significant reductions. But I think it's also telling to look at which presidents they are. These are not knee-jerk conservative politicians. This has been a bipartisan practice of adjusting national monument boundaries based on whatever political factors matter to the president at the time. But to give you a few examples to explain just how significant they were, the greatest as a percentage of a pre-existing national monument was done by President Taft. He reduced the Navajo National Monument by 90%. Several presidents collectively over a series of years removed hundreds of thousands of acres from Mount Olympus Monument. And others have been reduced by between 25 and 50%. Some of those created political controversies. Some of those didn't bother anyone. So those reductions are where we've gotten some of these monuments put into national parks. Some of them have changed the president's power. But one of the things that's interesting is if you look at the reasons why the reasons the presidents have given for why they were doing it, they're all over the map. Some say, we want this land to be used for economic uses. Some say it's a national security concern. Others, one, which I thought was funnier, was the president said, I already built the Air Force Base there, so there's no reason for me not to take this out now. Timber harvesting is cited, and many other reasons have been given. And essentially the historical practice is, just as the president can decide to designate or not designate a monument based on whatever political factors he wants to consider, the president can modify or revoke national monuments based on whatever political factors he wants to consider. That's what happens when you give the president this broad discretion to exercise unilateral executive authority. One point quickly to make on that, as Professor Squillace has noted, all of these pre-exist the FLIPMA, but as a legal matter, that is irrelevant. If you look at the text of FLIPMA, it leaves the Antiquities Act as is and makes absolutely no change. The only reference to the Antiquities Act is in, I forget the actual statutory section, but it deals with the Secretary's power to generally modify withdrawals. There's a provision that says the Secretary may generally make whatever withdrawals and modify whatever withdrawals he wants, and there's a series of exemptions from that, and one of those is the Antiquities Act. So it makes sense to include that. If you are generally giving the Secretary this power and want to withhold it somewhere, you're going to have to say so explicitly. The only reference that even suggests the president doesn't have this power is some ambiguous legislative history. But we know through more cases than I could possibly cite that legislative history can never change unambiguous statutory text. Statute says Secretary, not the president, and there's no ambiguity there. And post-enactment legislative history can't change the interpretation of a statute. So this came 70 years after the Antiquities Act. It cannot change what the Antiquities Act means. And it actually would be unconstitutional to do that. So Congress can't change a statute through enacting a unicameral resolution. Clearly it can't do it by approving a House report. And the last point on the purpose is, I think the challenge for making an argument based solely on purpose, which many of these ultimately boil down to, is that the Antiquities Act never requires a monument to be designated. And that's a challenge. So you can't say Congress's intent was to protect all of these things forever. If it meant to do that, it would have said the president shall designate every monument that meets these conditions. And it didn't do that. It gave wide-ranging discretion to include any political calculations you want. It is absolutely clear that on January 19th, the president could refuse to designate a monument because it would be unpopular in the local populace, or it would be economically harmful. What sense does it make to say that if a president designates one on January 19th, on January 20th, it would be contrary to the purpose of the statute to consider those same factors in changing a monument? So where does that leave us? As I said at the beginning, this is a political issue, not a legal one. If you're concerned about permanently protecting these lands and many other lands, your resolution lies in Congress. We already have several ways to protect federal lands relatively permanently. I mean, any legislation can be amended. The Constitution can even be amended for that matter. But when Congress wants to protect lands, it creates a national park or wilderness area. And because it takes an act of Congress to create them, it is really hard to change those. It requires new legislation to do it. One of the ironies here is that the legal argument against the president's power is essentially trying to convert national monuments into national parks and skip the process where you have to create the broad political consensus to get Congress to create it in the first place. So ultimately the takeaway is, just as it is in every regulation or every other executive consideration, you have two options. Do I go to Congress, seek compromise, and get a statute that has permanency, or do I go my own way, issue a regulation or national monument designation? It's easier, but the cost of taking the easier route is that you might lose the next election, and the next president might reverse what you've done. And the same is true for national monuments as for every regulation you can think of. And so if you're concerned, go to Congress, try to work with your political opponents, and see if there's a way to protect some of these lands in a way that will actually be bipartisan. And I think that's all I had, so thank you.
Thank you so much, Jonathan, for bringing up those very interesting points. You made a few arguments, and we're going to give Professor Squillace just a couple minutes while I'm setting this up here to respond to them. I think it also is important for all of us here to remember that national monuments can be designated by the president, or they can be created by Congress. These national monuments, as created, are legally indistinguishable. So there's also this question of whether or not a presidential power to revoke or rescind a national monument created by a previous president also extends to those created by Congress.
You want me to respond now?
Yeah, I'm going to set this up here.
Okay. Thanks, Michael. Yeah, so this is a good discussion. My only regret is that we don't have a judicial panel here to sort of debate. I feel like I'm in rebuttal mode right now, and I have to respond to some things that John raised, and they were good arguments, but I want to point out a couple of things that I think are important here. So I agree that this is no powers, and I think we just have a somewhat different view of how that works here. We repeatedly brought up the concern about the government's authority to promulgate regulations and to amend or change those, but what he did not tell you is that regulatory authority is delegated through the APA, and the definition of rulemaking in the APA specifically says that the agency has the authority to promulgate, repeal, or amend a rule. It's quite explicit. So yes, it's like the Forest Service Organic Act, for example, and explicitly calling out the authority of the agency to not just promulgate, but also to amend and repeal. That's not true under the Antiquities Act. The other thing I want to point out, he was talking some about executive orders. He paints with this broad brush about executive kinds of powers. Most of those executive powers, like the DACA administrative order issued by Obama, that's power that's being exercised under Article 2 of the Constitution. It is not the legislative Article 1 power. And you really need to distinguish between these things. And when the president issues a proclamation under the Antiquities Act, the president is exercising power under Article 1 that was delegated to the president to take that very narrow, specific kind of action. We can get into the questions and debates more in the Q&A. I think that's probably the best place to do this. I just want to make one other point that I think is worth noting here. John showed you that slide with the huge bump in the number of acres of land that has been designated. And I just think that's really misleading. We could debate this point, John, about it, but what happened, of course, and many of you know this, it's probably being discussed in the other panel that's going on, is that beginning with President Obama, some really big, I guess with the beginning of President George W. Bush, there were some massive monuments designated in the Outer Continental Shelf of the United States. And if you include the acreage in those massive marine monuments, the chart looks a little crazy. But if you just look at the land-based monuments, it's not quite so crazy. I think it's a rational kind of a bump up in the number of acres. But we'll get into this more during the Q&A. I'm sure John has some things he'd like to respond to, but I want to make sure you give Chantel an opportunity to say her piece as well.
Yeah, we're going to give John 1 minute. I think he has one.
I won't even take that.
Oh, okay.
Just 10 seconds. On the can you distinguish regulations, it is black letter law that the EPA does not give agencies any regulatory authority. It sets up a procedure for exercising it. But the ultimate delegation of authority has to come from whatever the organic statute is. EPA just doesn't convey any authority, either to issue rules, modify, or give it just to set the procedure. So I don't think that distinction will work.
Awesome. Well, thank you, Professor Flacci and Jonathan, for giving us a nice back and forth here. I'd like to now have us shift gears to understanding one of the non-legal aspects of national monuments, which is especially prevalent in those in Utah, which is indigenous understandings. So we have Chantal Carmardel, who is the secretary for the Isle de Jean-Charles Biloxi Chetamachma Choctaw tribe, and she's going to be giving us just a little bit of an overview of how these type of legal arguments that we're discussing are understood by those who lived there for thousands of years. Chantal?
Thank you. So, I think they're both wrong. But interesting, that's very interesting, both points, to see both points. And from an indigenous perspective, we do feel y'all are both wrong, because it is totally not about whether it's declared private land or public land. It's our land, and it shouldn't have been taken away in the first place. So we live by the land. One interesting picture that I saw with and your presentation was the one with the circles. You know, that's now just outside of the borders. And who can look at that and say that it's not scientific and needs to be preserved? Just like all the other places in the Two-Bear area that should be preserved. These are all Native American lands. There's plenty of caves and dwellings and artwork and things, you're right, that has never been discovered that we need to look at. What he put up there? Yeah.
This map just shows the indigenous population. They are the largest ethnic group in the United States.
Right. So, I mean, you know, we have to look at that. We have to look at the impact this is going to have on the people, on the landscape. It's not just a matter of, you know, what's this land going to be used for? We've already seen looting. That discovery that you said, that was the whole purpose of the Indian Religious Freedoms Act. You know, that was the purpose for the Antiquities Act, is to stop looting. And what is going to stop people from going to these places? It needs to be preserved. It's not just that one space, it's that whole span around it. You know, we're dealing with that locally here. It's not just the coast that's disappearing, it's the people. You know, there's a whole aspect of this that's being argued. Is this a political issue? Is this a legal issue? It's the people issue. This is a land issue. This is a people that's connected so greatly to the land. This is how they survived for thousands of years. They didn't ask the government to come in and declare this federal land, declare this protected land. It was. They lived there. It was protected. It was their place. They knew not to loot. You know, it's when you have and I'm speaking from the other perspective, you have the museums that come in and just, you have this anthropologist that came in and just raped the land and raped all the artifacts. I'm just recently a certificate of museum studies graduate and studying how that's happened from an indigenous perspective. It is horrific what has happened. And these communities in this area is going to have to deal with that all over again. And that's a shame. We shouldn't have to. There was a reason it was designated so large, because it was proposed that it needed to be that large. And we should protect it. The president should honor that. It shouldn't have gone back. So, you know, we have an opportunity to do something right, and the president has an opportunity to do something for the people that he's supposed to be representing. And I don't think this was the best choice for the people of that area, for the people that he is supposed to be representing as their commander-in-chief.
Thank you very much, Chantel. The demand for artifacts found illegally, looted, in Bears Ears and Grand Staircase continues to be very high to this day, to the point that there are numerous fakes out there on the black market. The demand is that high. So thank you, everyone, for discussing these issues related to national monuments. I think we will open the floor for questions.
Thank you all. Good to see you again. I guess this is more a question for John and Mark. Do either of you see a legal distinction between revocation and shrinking?
I think we actually agree, and the answer is no. The only distinction it would be that 1938 AG opinion, which tries to draw this distinction. But you know, that's not a court decision, not precedent, and I think it's not very persuasive. You know, the bottom line conclusion of that is revoking national monument can't be allowed because that would be tantamount to repealing the Antiquities Act, and I don't think anyone would buy that argument presented to the court. Like, no one would go to court and say, you know, if a regulation were repealed, that effectively repealed the statute, and so the agency is no longer bound by any obligations under the statute.
Does that undercut the historic precedent, though? Since
Well,
nobody has ever revoked.
it's also never been considered by a court, and all it would take is the president deciding to revoke it. I mean, AG opinion is pretty easy to change. So it's part of the historical story, but I think it would be hard for a court to try to take that line saying that revocation and modification.
I think the point Victor's making is that since there are precedents for presidents shrinking monuments, does it undercut your argument about the authority to shrink if you don't accept the distinction? Basically, I think I agree with you, John. It's going to come up one way or the other for both, and we'll see which way it comes out. So I don't really think that those precedents are particularly important. I did mention that Congress has actually revoked about a dozen monuments, all relatively small, no significant monuments revoked by Congress.
Question now for John on that. I take the presentation.
You okay?
Oh, did he fall off?
I tried to look at you, not realizing there was a step.
Sorry, I'm guessing that's not the first time they had it.
What a question.
I took off his chair. I took at the end of your presentation you suggested there isn't a sort of a legal or structural limit on the reason or rationale the president can revoke to, assuming he had the authority to shrink or revoke a monument. I was wondering if that is the case, and that any different if you're suggesting that the president would have to specifically assert the kind of scientific and historical preservation purposes to designate, but would not have to make such findings shrinking, and whether you could also address the New York Times article recently that suggested, based on FOIA response, that there were reasons other than related to finding the smallest size consistent with preservation.
So first, you have interpreted my argument correctly. I think that the president has the same discretion to modify or revoke national monument that he has to refuse to designate one in the first place. That the Texas statute just limits the circumstances where a monument be designated, but doesn't dictate the factors used to decide whether to do so. So the same sort of unlimited discretion that applies to the designation power applies to the publication or notification power. I saw the New York Times story. I haven't had a chance to go through all of the FOIA documents themselves to see. So some of them I've seen people have, I think the state of Utah said, this is land we count on to fund our schools, and if it were open for oil, that might be a funding source. It's interesting. I will be curious to go through it, but ultimately it's a political issue, and you can make whatever political hay out of it you can. But there's no question as a legal matter that if the president were considering designating a monument and found out there might be oil there, he could refuse to do it on that basis, no matter how clear the case of designating would otherwise be.
But the president could do something on unconstitutional grounds like race.
Right.
The president could say, I'm not going to designate that because it's going to help people of color or something like that.
But as I understand, there's no sort of constitutional or equal protection problem. That he considered political factors that some people might like, some people might not like, and as a political controversy, absolutely. But as a legal matter, I don't think it changes.
I'm just wondering, back in constitutional questions, is there any issue with sovereign immunity and like okay, we don't have an agency here, we don't have the APA, what's the basis for assuming the president acts?
In the DC Circuit has considered this question, and there's a doctrine of implied right to challenge executive discretionary actions, as the Circuit has recognized for a long time. The precedent only exists there, so if the case gets moved to Utah, as the government has proposed, I'll be curious to see what happens. But as long as it stays in DC, it'll be analyzed. It's not an APA action, but it'll be analyzed in a very discretionary level.
Yeah, I mean, I think that the Supreme Court has suggested that the president can be sued. You just can't apply the APA. The Franklin and Massachusetts case suggests as much. And the D.C. Circuit, I think, has made clear in the Tulare County versus Bush case that you can sue, if Jonathan is suggesting that you can sue the president. It's tricky because, of course, you can't sue under the APA, and nobody knows what that means in terms of the rules that apply. The court kind of has to make it up. But I don't think that's going to be the hurdle that we need to overcome.
I was interested in the moderator's comment that this would have an effect on the looting or the prosecution of looting of archaeological sites. Because my understanding is it's all federal land before. Are there different laws that apply if it becomes a national monument? Because here my recollection isn't perfect, but sometime in the last 10 years, there was a huge federal case over looting that was right in that area.
Yeah, you're referring to the case in the 1980s. Yeah, so there are laws in place to already protect these sites, making it criminal to remove items. One of the problems with them, though, is increasing access, easy, open access, for example, through the use of off-road vehicles, greatly enables looters to prosper.
And to that point, modern monument proclamations generally prohibit the construction of any new roads, and off-road vehicle use is generally prohibited. So it gets a little bit complicated in each individual case. I guess the other thing that changes is that management becomes more robust in the case of a national monument. And we've seen that, for example, in Grand Staircase. national monument, where there, at least until the changes that have been proposed or that have been suggested by the president, there's a much more significant management structure in place there.
And the Bureau of Land Management estimates that there are 24 archaeological sites per square mile, undiscovered, right? And archaeologists are very keen to keep these sites preserved, simply because these ancient cultures achieved levels of agriculture and civilization that we cannot duplicate today. These people grew corn and squash in an area where we, with irrigation and everything we have, cannot. So they put an important aspect for our own future.
This guy's more passionate than I am about this topic here.
I'm curious, what trumps what, as far as a treaty,
No pun intended?
no pun intended, treaties or antiquities? And then, if treaties were what was there for the land and the management of the land by the tribes, what then, when the antiquities comes in, how is that management and that oversight changed?
Well, this is the first, Bears Ears is the first monument to have this type of management, right? National monuments can be managed.
Treaties, though, in general, like.
Native American, treaties with Native American
Yes,
communities.
like Olympic National Forest was all treaty land.
Well, it's no longer treaty
No longer.
land. I don't know that it was at the time of the proclamation. Maybe it was. That was 1909, I believe, when it was. The Mount Olympus monument was 2 days before Roosevelt left office, so it would have been early 1909. And I don't know the exact status of the land. I don't believe that generally they designate. I'm trying to think. Is the Navajo National Monument on Navajo land?
I don't know.
I'm not sure.
Canyon de Che, I think, is the only one.
So, what the statute says is that the president can designate national monuments on federal lands that are owned or controlled by the federal government. So it has to meet one of those criteria. The controlled issue has come up recently with regard to the marine monuments, which is another interesting question
At
that
a
we can
minimum,
talk
it's
about.
clear from legislative history that that would include Indian lands. The
Right.
control was definitely at least about that.
Right.
Different history, having controls trees.
Yeah.
Fair enough.
Does anybody know, has anything physically changed the monuments? If you drive through that area, both Escalante and, there's no sign that says, welcome to drive on a highway. If there were, have those signs been moved? Have the tourist offices hand out different maps showing the boundaries?
Right, so we have a difference between monuments that are managed by the National Park Service versus those that are managed by the Bureau of Land Management. The Park Service takes a much more robust approach in distributing, creating literature and all that. While BLM is...
Well, so Bruce Babbitt had this idea when he was Secretary of the Interior to give some of the monuments over to the BLM to manage. It was the first time during the Clinton administration that monuments were made available to the BLM to manage. And I think Babbitt's vision, which is largely played out, was that the BLM should maybe take a somewhat different approach to monument management. It wasn't going to be with a visitor center inside the park, sort of encouraging people to go into a small area and not explore the larger area of the monument. The idea was that maybe there would be visitor centers, maybe people would be encouraged to come, but they would be in the local communities outside of the park. And that's what happened with Grand Staircase. So if you go down to the town of Escalante, which is southwest of the monument, or it's actually in the middle because Kaperowitz is up above it, there's a major visitor center. It was at least initially run jointly between the BLM and the Park Service.
Have they changed the maps they're handing out?
I mean, I don't think so. I don't think they were really ready for the changes. So I think they're still probably, I don't know what they're telling the public in terms of what's being protected and what's not, but obviously it's in litigation. I doubt that any maps are going to be changed until we see how the litigation plays out. And Bears Ears, of course, is too new. So there's not really any effort yet to set up a visitor center.
You never know when you're there or you're not there, even without the shrinkage.
If you drive over that road, by the way, just as sort of a point of information for those of you who might get down to southern Utah, drive the road between Boulder, Utah and Escalante, Utah. it will kind of change your view of America. I mean, that is one of the most spectacular roads you will ever be on, and there's just some tremendous hiking off of that road in lots of places. I'd encourage everybody, at least once in your life, put it on your bucket list. It's really an amazing place.
Could I go back to First Peoples and to Chantal Palmerdale? I'd like to ask you whether you view the Native American relationship to Bears Ears in this particular area as religious. And then I'd like to say, ask the our two law speakers whether, if her answer is yes, then whether there's a religious freedom act aspect of this, and whether the president is constrained by that act, or would be constrained if that relationship were directed. So, Chantal, could you?
Yeah.
I think I'm asking all three of you something.
Yeah, I do think it is a religious freedom act issue because of the amount of artifacts and the amount of things that these people lived here and that was their culture. It's bound to be protected. We have a right to have it protected. So I
on
do
the
think
witness
it's an
stand,
issue.
Chantal, and someone asked, is that religious? How would you answer that question?
Religious because as a first people, you have a relationship to the land is just as much a spiritual connection as it is to a cross for a Christian. As first people, our land, we're connected by spirit to our land and to all the elements around us. So it is a spiritual, and so therefore being a religious part of being a religious act.
Parenthetically, for those of you here, the Supreme Court rejected that relationship in the Obama case involving a Native American tribe in the Pacific Northwest. And that was the key reason for passing the Religious Freedom Act. So I think that syntax, cultural and religious, might apply here. Now I'd like to ask whether that has anything else to do.
I mean, I don't know if Matt's which one goes. I mean, I think as a legal matter in the Antiquities Act, the answer is no. If you could find racial animus, that's a very different problem, but I haven't heard any indication that there's.
Well, I think the
but-
Religious Freedom Act, it doesn't require animus.
But it also doesn't require a monument, right?
Right.
So I think I probably agree with John on this. I think that there could be implications. Certainly, the tribes have raised issues about their ability to gather plants and other medicinal plants and other things within what was the original monument boundaries. There was a tribal commission that was set up by the Obama proclamation that was going to help to arrange for the management of the monument. That's obviously been significantly changed. I think the commission is nominally still in place, but with a tiny fraction of the original monument, including a lot of lands that the tribes really wanted to include in the monument. So there could be issues, but I don't know that they're necessarily dependent upon having a monument over those lands.
I think that as far as I understand their position, the reason they're not pursuing that is because they would be required to prove that they could no longer practice their religion at all under the new monuments, which are heavily reduced but do still maintain some areas. The Navajo have documented extensively their religious ties to specific areas, and that's the map right there.
You keep drawing this comparison between the power branches of the president in this act and the power of agencies to promulgate regulations. I'm not quite sure if that's a proper analogy. Assuming that it is, can you give any examples of when Congress is not sure to include when they're granting power to an agency, they don't include all the words promulgate and modify? Are there any examples?
So there are dozens. I'm happy to send the written materials that provide some of the citations, but I actually just litigated a case like this in the Ninth Circuit, where I thought Congress had been clear enough to prevent an agency from reconsidering. The statute said it gave the agency a discretionary power to set conditions if the agency accepted. So it said if you go forward, you must adopt
language in the statute contains something like the agency may issue a regulation. The general rule will be that the agency can modify or revoke the regulation, and it takes a lot to overcome that.
Just to clarify a point that I may have misspoken earlier, when Jonathan pointed out that the APA doesn't actually delegate particular authority to regulate, but it does define rulemaking. It does define rule, and those definitions are applicable to virtually every agency that engages in rulemaking. So if Congress delegates the authority to do rulemaking, the terms of the APA bind the agency in terms of how they do rulemaking. They have to do notice and comment and all the kinds of things that are set out in the APA, and they're bound by the definition of rulemaking, which explicitly includes the authority to amend or modify or amend or revoke regulations. So I'm comfortable with our position on that issue. Jonathan's obviously comfortable with his position, but we'll see what the court has to say.
And you could do similar things to the argument we've had here. There are some statutes that expressly offer the Clean Air Act as a provision lets governors request amendments to regulations. But no one would say, well, there's something specifically authorizing revocation or modifications that none of the other statutes authorize. I think it takes more of a smoking gun than a few other statutes.
So this is a question for both of you. And it has to do with John's point that the president can decide to revoke or shrink national monuments and their predecessors willy-nilly. A reason or no reason, perhaps he woke up in the morning with some box and the president just decided, I don't like this monument anymore, and I hereby revoke it. Assuming that the Trump new proclamation is about justicial, something that seemed to be assuming, but not necessarily examining, the Franklin case, for example, has been interpreted, you probably know, to preclude review of residential permits or cross-border pipelines and other things, period. So there's that. But assuming it's justicial, is it really true that Trump could say, I'm drawing these boundaries to exclude uranium, oil and gas, and coal, period. That's why I'm doing it. I'm not doing it to identify objects of scientific importance. I'm not doing it to designate the least amount of area to protect such objects. I don't care about anything. What I care about is the fact that there are fossil fuels and minerals of value to extractive industries. That's what I care about. That's why I'm doing it. Is it really true, Mark and Jonathan, is it really literally true that a court would say, yeah, that's okay. It doesn't have to be connected to or tethered to the text of the statute, the administrative record that was developed to designate these areas in the first place, to use ecological data, historical data, archaeological data. None of that matters. Is that really true? Not that you have.
You want me to go? So I'm kind of interested.
Particular view on it.
So I'm kind of interested in what John has to say about this. But
I think the answer is yes. I don't think that's the approach they're going to take, and I understand they're probably going to try to argue that the original monument is too big. But I think they could, and the reason is that a president could refuse to designate a monument in the first place for precisely those reasons. And this is one of the reasons why I said this is ultimately a political issue. If you don't like that result, you should want to amend the statute to make monument designations mandatory. You probably have to give up some circumstances for where they can be designated. That might be cabin some. But as long as monuments never have to be designated in any circumstances, no matter how clear the case for it is, I don't think there are any restrictions on the president's ability to exercise this.
right, I thought that's what John was going to say, and that sort of sets me up with two responses, I guess. First of all, our basic position is that it's one-way authority, so the issue doesn't come up, and so we would basically take the view that once Obama designates Bears Ears, that's the end of the matter. Unless Congress decides to intervene. Of course, that's one side. But then the other
is you can do whatever you want.
Well, no. So the other question is, I think it's a little narrower than that, and we'll see, because I think that certainly the court in Wyoming and Frankie, and I think the court in the Tulare County case in D.C. also suggested that they would probably consider an arbitrary and capricious argument. Now, remember, it's a really interesting point, right? Because there's no clear standard of review. It's not the APA, which would be presumably an arbitrary and capricious standard. I think our side of the case doesn't want to go there just because it's so fraught. And if we're right on the initial question, we never have to go there. But the other courts that have considered it, that have looked at the evidence, have suggested, and by the way, they've looked at the evidence only on the side of could the president initially designate, and whether that was arbitrary and capricious. I'm more comfortable with that than the idea that now we're going to ask, okay, once the president is designated, can some new president come in and decide that the original proclamation was problematic? That takes it another step that I think is going to be problematic for the courts. And I don't know, but my suspicion is that courts are not going to want to get into that. It could very well involve sort of extended kinds of hearings, because what's the basis?
All or nothing, Mark? It's an up or down.
I think a court is going to be inclined to look at it as an all or nothing, but I think even if they don't, there is this sort of residual argument that our side would probably make.
How do you distinguish between the situation and the 6 other instances where prior presidents have made modifications to national monument designations?
It's more than 6. I mean, the only point is that it's never been challenged in court. So we don't, I mean, I would take the position that the original modifications that were done were not valid. I mean, whether you could still litigate those issues, it seems to me that latches or something else would probably bar litigating those issues. As I mentioned, the big one, the 300,000 acres in Mount Olympus, was basically put back into the park when the park's designated. So a lot of these, it's sort of water over the dam now in terms of those kinds of issues. But we've not heard the court offer an opinion, any court offer an opinion about whether the president can modify a monument. So that's the big issue that we're going to get resolved here, I guess.
Well, thank you, everyone. And thank you all for joining us. If you have any further questions, I think our panelists will be here for a few minutes extra.